Picture this: a foreign developer wants to build a luxury condominium near a protected wetland. The investor says the land is perfect. Let's start construction. But the local lawyer hesitates and says, we will need to review the zoning map and the environmental regulations first. This is where real estate law becomes more than contracts. It's about balancing private projects with public regulation. In today's lesson, you'll learn how to explain zoning categories, permits, and compliance requirements in clear professional English, the language lawyers use when projects meet the law. By the end of this lesson, you'll be able to speak about real estate development. You'll learn the vocabulary needed to describe zoning plans and construction permits, and practice explaining why certain legal restrictions exist. We'll also analyze how to use cause and effect language. Expressions like because of zoning limitations or as a result of noncompliance to connect facts and legal outcomes clearly when advising clients or preparing project documents. Imagine this scenario. An international development group buys coastal land to build a luxury resort. The investors expect construction to start immediately. They've hired architects, arranged financing, and even begun marketing. Then, the local legal team reviews the municipal plan and discovers a problem. The property lies within a protected coastal zone. Under zoning laws, that land can only be used for limited purposes, such as conservation or small scale tourism, and requires special environmental permits. The investors are shocked. We already own the land, they protest. But the lawyer explains ownership doesn't guarantee development rights. Land use depends on zoning classification and compliance with public regulations. This is where legal English becomes critical to explain complex restrictions clearly and maintain trust. And now reflect. What arguments might the developer make? Or how can the lawyer present these limitations without losing the client's confidence? Zoning regulations are the foundation of modern land use control. They define what activities are permitted on specific parcels of land and set physical limits such as building height, density, parking requirements, and distance from property lines. For example, a plot in a residential zone might prohibit retail activity, while a commercial zone could require public parking access or fire safety compliance. Lawyers working with developers must interpret zoning ordinances and review municipal maps to ensure the proposed project aligns with the applicable use. If a building is constructed in violation of zoning rules, local authorities can suspend permits, impose fines, or even order demolition. Zoning is not static. Cities revise their plans regularly to reflect environmental, social, and economic priorities. Therefore, advising clients means not only knowing the current regulation, but also anticipating how future amendments could affect long-term development rights. When a project does not comply with existing zoning, the developer's legal team may request a rezoning or a variance. Rezoning changes the property's category entirely, for example, from agricultural to residential, and usually requires a public hearing, municipal approval, and sometimes an environmental review. It's a political as well as legal process because neighboring property owners and local communities can object. A variance, on the other hand, is a limited exception. It allows a property owner to build slightly beyond normal restrictions. For example, a taller structure or a smaller setback, when strict enforcement would create unnecessary hardship. Lawyers play a critical role in drafting petitions, presenting legal arguments, and demonstrating that the request is consistent with the public interest. Success often depends on detailed evidence, community consultation, and persuasive reasoning grounded in both law and planning policy. Even when zoning approval is obtained, a project cannot begin until the developer secures the necessary building permits. These are issued by local authorities after confirming that architectural plans comply with all applicable building codes, standards designed to protect public safety, energy efficiency, and environmental sustainability. For instance, codes may regulate the strength of foundations, fire exits, structural materials, and accessibility for people with disabilities. A lawyer's responsibility often includes verifying that all permits are valid, current, and cover the intended scope of work. If construction proceeds without proper authorization, authorities may issue a stop work order or revoke the developer's right to continue operations. In large scale projects, compliance must also be maintained through periodic inspections and certifications. Understanding this process helps lawyers communicate effectively with engineers, inspectors, and project managers to prevent costly delays and legal disputes. Land use planning provides the big picture framework for zoning decisions. A master plan, sometimes called a comprehensive plan, sets out how an area should grow over the next decade or more, identifying residential districts, industrial zones, transport corridors, and conservation areas. It's not just a policy guide, it's often a binding legal reference used by planning commissions when approving projects. Lawyers must understand how their client's property fits within this broader strategy. For example, a developer proposing a new shopping center must confirm whether the master plan designates that region for commercial activity or for green space preservation. Disregarding these plans can result in legal challenges from public authorities or environmental groups. Skilled legal professionals interpret planning language, advise on consistency with policy goals, and draft submissions that align private projects with public planning principles. Many jurisdictions require developers to conduct an environmental impact assessment before obtaining construction permits. The goal is to predict and minimize negative effects on air, water, wildlife, and local communities. An EIA typically includes scientific studies, public consultations, and mitigation plans. For instance, if a housing project may increase traffic or damage wetlands, the developer must propose solutions, such as infrastructure upgrades or conservation buffers. Lawyers assist in preparing EIA documentation and ensure compliance with environmental statutes. They also defend or challenge EIAs in administrative or judicial proceedings. Understanding environmental vocabulary, terms like mitigation measures, threshold of significance, or public participation is essential for legal professionals working in real estate or infrastructure development. Ultimately, a well prepared EIA not only protects the environment, but also reduces litigation risks and improves public trust in large scale projects. In many countries, development projects cannot proceed without public hearings or community consultation. These procedures ensure transparency and give residents an opportunity to raise concerns about environmental, social, or aesthetic impacts. For example, before approving a new factory or high rise complex, municipal councils may hold hearings where citizens comment on noise, traffic, or public space issues. Legal teams must prepare clear presentations, anticipate objections, and document compliance with procedural requirements. Effective lawyers frame arguments that show how the project aligns with public interest. For example, job creation, infrastructure improvement, or sustainable design. Poor community engagement can lead to protest, political pressure, or even cancellation of permits. In advanced legal practice, lawyers balance persuasive advocacy with diplomatic communication, demonstrating that development and community welfare can coexist under the rule of law. When large developments are approved, governments often require development agreements to specify how the private project will benefit the community. These contracts may include infrastructure contributions, such as financing roads, water systems, or public parks. Lawyers negotiate these agreements to balance the developer's financial capacity with public expectations. A poorly drafted contract could impose excessive costs or fail to guarantee timely completion. These documents are legally binding and may be registered against the land title. They often reference detailed engineering schedules, deadlines, and compliance clauses. In cross border projects, lawyers must also consider investment protection treaties and local procurement laws. Understanding this vocabulary allows legal professionals to draft, interpret, and negotiate terms that satisfy both private investors and government agencies, minimizing future disputes and ensuring long term project viability. Occasionally, a development project cannot proceed without the government acquiring private land. For example, to build highways, airports, or public utilities. This process, called expropriation or eminent domain, is a lawful but controversial tool of land policy. Lawyers represent both public authorities and private owners in these proceedings. They evaluate whether the project serves a legitimate public purpose and whether compensation offered reflects fair market value. Disputes often arise over valuation methods, relocation costs, or alleged abuse of power. International investors may also invoke investment treaties to claim additional protection. For legal professionals, mastering this terminology is essential for advising clients, negotiating settlements. For legal professionals, mastering this terminology is essential for advising clients, negotiating settlements, and ensuring procedural fairness. The ability to explain expropriation law clearly can determine whether a client accepts negotiation or pursues litigation in national or international forums. In legal communication, cause and consequence structures help us explain how facts connect to outcomes, the foundation of persuasive reasoning. Let's look at each example. Because of zoning restrictions, the developer had to redesign the project. Here, the law directly caused an architectural change. The phrase because of introduces a straightforward factual reason. Next, the permit was revoked due to noncompliance with fire safety codes. Due to sounds slightly more formal and is common in written reports explaining administrative actions. Then, as a result of public opposition, the city postponed approval. This expression emphasizes the effect of a social factor, the decision to delay. The environmental study was incomplete. Therefore, the application was rejected. Therefore is a logical connector, often used in judgments or legal opinions. The land title was unclear. Consequently, financing was delayed. Here, consequently shows a financial impact flowing from a legal uncertainty. And finally, verbs. Failure to obtain the EIA led to a court injunction, and irregular bidding procedures resulted in the cancellation of the contract. These dynamic verbs summarize cause and effect clearly, ideal for concise legal summaries or oral explanations. In development contracts, the phrase subject to planning approval protects both the developer and the buyer from premature commitments. It means the agreement is conditional. The project cannot legally begin until the planning department authorizes it. For example, a purchase agreement might state completion of this transaction is subject to planning approval for a mixed use complex. If the permit is denied, the buyer may withdraw without penalty. Lawyers use this phrase to manage risk, ensuring that clients are not bound to an unbuildable project. It also clarifies the timeline for financing and construction. In some jurisdictions, failure to secure approval within a set period can void the agreement automatically. This phrase is critical in correspondence, contracts, and due diligence reports, a reminder that in real estate development, legal permission often matters more than ownership itself. When a lawyer writes that a project is in compliance with local ordinances, it signals full adherence to the city's building codes, zoning plans, and environmental rule. This phrase appears in legal opinions, planning submissions, and compliance certificates. For instance, the development plan has been reviewed and found to be in compliance with local ordinances relating to height, parking, and public access. Such statements can determine whether financing or insurance proceeds. Lawyers must verify this carefully. A single overlooked rule can expose the client to administrative fines or construction delays. In professional communication, the opposite phrase, not in compliance with, carries serious legal weight. It may trigger stop work orders, contract termination, or even litigation. Understanding how to phrase compliance statements precisely gives lawyers clear, defensible advice to clients and regulatory bodies. Change of land use is more than a bureaucratic formality. It's often the first legal step in transforming an idea into a viable project. It occurs when a developer wishes to use land in a way different from its current zoning designation. For example, talked about before, converting farmland into residential property or turning an old factory into offices. This process typically requires public notice, environmental review, and approval from a planning commission. Lawyers prepare applications demonstrating that the proposed use aligns with the city's long term development goals. For example, the applicant requests a change of land use from industrial to commercial to allow the construction of a logistics center. Understanding this phrase helps legal professionals advise on feasibility and timelines. A denied application can halt a multi-million dollar project, while a successful change can dramatically increase the property's market value. A certificate of occupancy, or CO, is the final milestone in the construction process. It legally confirms that the building meets every requirement: zoning, fire safety, sanitation, accessibility, and is safe for people to enter. No tenant can move in, and no lease can be executed until this document is issued. For example, the landlord shall deliver the premises with a valid certificate of occupancy at closing. Lawyers often coordinate with architects, contractors, and inspectors to confirm compliance before signing the handover documents. If a project lacks a CO, it cannot be legally occupied, and insurance or financing may be invalidated. In advanced legal English, this phrase frequently appears in contracts, closing documents, and municipal correspondence, representing the final stamp of legal approval for any completed development. The City Council approves a new riverside commercial complex, subject to planning approval. Investors are enthusiastic, but soon problems emerge. The land falls within a residential zone, and the design exceeds the height limits set by zoning regulations. Because of these restrictions, the initial permit is denied. the developer applies for a change of land use and a variance to continue the project. Due to public opposition and concerns about parking, the Planning Commission postpones the decision. As a result of these delays, financing becomes uncertain. The lawyers must demonstrate that their revised design is fully in compliance with local ordinances and consistent with the city's master plan. After an environmental impact assessment and several public hearings, approval is finally granted. Construction resumes, inspections are completed, and a certificate of occupancy is issued. Therefore, the complex officially opens 2 years later than planned, but without any legal dispute. This case shows how strong legal English, clear cause and effect language, precise vocabulary, and technical phrases helps lawyers explain challenges professionally, negotiate solutions, and maintain trust between clients, authorities, and the community. In this lesson, you explored how real estate development operates at the intersection of private investment and public regulation. You learned key vocabulary like rezoning, variance, building permit, and environmental impact assessment that lawyers use when guiding clients through planning procedures. You also practice advanced grammar to express cause and consequence. Structures such as because of, due to, as a result of, and led to, essential for explaining why certain legal outcomes occur. We then examined technical phrases like subject to planning approval, in compliance with local ordinances, and certificate of occupancy, which appear in real contracts and legal opinions. Finally, through the development story, you saw how lawyers manage public hearings, compliance checks, and community concerns to keep a project lawful and on schedule. Your takeaway: clarity in language equals control in law. Precise, structured English lets you explain facts, justify actions, and protect your client's interests, the essence of professional legal communication.